Amendment to H.R. 572 offered by Ms. Spear of California. Page 2, line 13, insert A after...
Without objection, the amendment is considered as read. I recognize my colleague from California for 5 minutes to speak on her amendment.
Thank you, Mr. Chairman, for this opportunity. I want to commend Mr. Ellsworth for introducing this accountability measure. While we want to prohibit any contractor who is seriously delinquent in his tax debt from obtaining a federal government contract or grant, there is language in the bill which allows for flexibility for heads of federal agencies to respond to those circumstances. And while we need to provide that flexibility, I think it's important that Congress and the American people have the right to know when these circumstances occur. So when there is a waiver of this provision, there would be required, as a result of this amendment, a report to Congress within 30 days by the agency head as to why the waiver was provided. That's the gist of the amendment, and I yield back.
Right. I thank the gentlewoman from California. Do any other members wish to be heard on an amendment?
Mr. Chairman.
Mr. Chaffetz from Utah.
Mr. Chairman, I just want to offer that I like this amendment. It's common, open government. It provides a maximum transparency. I appreciate the offering of the amendment, and I would encourage my colleagues to support it. It seems like common sense and the right thing to do.
Right. Thank you very much. Thank you, gentlemen. This is probably history, supporting 2 California amendments back to back. I support this amendment, and I thank my colleague from California for bringing it forward. It requires the critical reporting that is necessary for the proper oversight of this bill. If no other members wish to speak on the amendment, the question is on adopting the Spear amendment. All those in favor say aye. Aye. All opposed say no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. I understand we have another amendment to consider.
Yes.
I recognize my colleague from Utah, Mr. Chaffee.
Thank you, Mr. Chairman. I do have an amendment at the desk.
Amendment to
Clerk would designate Mr. Chaffee's amendment.
Amendment to H.R. 572 offered by Mr. Chaffetz of Utah. At the end of the bill, add the following new section, Section 5, ineligibility of persons having seriously delinquent tax debts.
The amendment is considered as read. I recognize the gentleman from Utah for 5 minutes to explain his amendment.
Thank you, Mr. Chairman, and I appreciate this bill. I've got to tell you that becoming more and more familiar with this bill, I ask that my name be included as a co-sponsor on this bill. My intention of offering this amendment is not in any way, shape, or form an attempt to try to kill this bill, and whether or not this amendment passes, I do plan to support the bill. I think it's good common sense. I think it's open and transparent. I think it's the right thing to do, and I think the taxpayers who are footing the bill should demand and continue to demand that if you're a contractor and you're getting federal dollars, that you be paying your federal taxes. By the same token, I also believe that that same principle applies when looking at federal workers. So my amendment simply expands it to say if you are also on the federal payroll with the same principles in place, that you should be, that these agencies should be allowed to dismiss you as a federal worker. Now, a report recently came out that unfortunately we have roughly 100,000 federal workers who are failing to pay their taxes. It accounts to about $1 billion a year in uncollected federal taxes. It fundamentally does not seem fair. In fact, Mr. Chairman, I would ask the unanimous consent to have President Obama's remarks of January 20th, 2010 entered into the record, if I may.
Without objection.
I'd like to read a couple excerpts from this, and I would hope that my colleagues would consider that the principle is still the same, whether it's a contractor or a federal worker. And in the President's words, quote, all across this country, there are people who meet their obligations each and every day. You do your jobs, you support your families, you pay the taxes you owe because it's a fundamental responsibility of citizenship. And yet somehow it becomes standard practice in Washington to give contracts to companies that don't pay their taxes. Again, I think the same principle is true with federal workers. Going on, later in his text, quote, the status quo then is inefficient and it's wasteful, but the larger and more fundamental point is that it's wrong. It is simply wrong for companies to take taxpayer dollars and not be taxpayers themselves. So we need to insist on the same sense of responsibility in Washington that so many of you strive to uphold in your own lives, in your own families, in your own business. And the last thing I'd like to quote, Mr. Chairman, is, quote, "Beyond these steps, I'm also calling on Congress to build the kind of legislation that Senator McCaskill, Congressman Ellsworth, and Chairman Towns have introduced, and that I introduced when I was Senator. Legislation that will crack down on tax cheats by allowing the IRS to share information about tax delinquency with contracting officials." It is that same, end quote, it is that same principle that should be applied to different departments and agencies. Now, currently, the IRS is the only agency that has this type of provision. I don't think it's a coincidence that the agency with the highest compliance rate of its employees paying their federal taxes is the IRS. I simply want the other agencies and departments to have the same type of latitude that the IRS currently has. And so this amendment, I would hope, would be viewed in the same sort of common sense type of viewpoint that the underlying bill is offered. There is a provision I would like to point out on page 2, where if you have an employee who is seriously trying to get out of this tax debt, there are exclusions where you aren't just automatically dismissed, but we are talking about people that, quote, have quote, seriously delinquent tax debt, end quote. If you're on the federal payroll, whether you're a contractor or an employee, I think it's common sense and the right thing to do to dismiss that employee or that contractor if they're not paying their federal taxes. Again, Mr. Chairman, I support the underlying bill. Whether or not this amendment passes, I will support it. But I think this is common sense. I think the taxpayers deserve and expect more. There are good paying jobs in the federal government. Most all of them do the right thing and they pay their taxes, but for that small portion of people who aren't, the agencies need to have the ability to be able to dismiss those people and do the right thing for the American taxpayer. And with that, Mr. Chairman, I'll yield back the balance of my time.
I'd like to thank the gentleman from Utah.
Mr. Chairman.
Yeah, you recognize the gentleman from Massachusetts.
Thank you, Mr. Chairman. I thank the gentleman from Utah for his courtesy. He had presented this amendment to me in advance. I chair the subcommittee on federal employees, and I have enormous respect for the gentleman from Utah, and I assume he's offering it through the noblest of intentions. But I do want to point out a difference between a federal contractor going after a federal contract and an employee. And that is, number one, a federal contractor going after a federal contract who is in arrears of on their taxes has a chance going into the process to correct that situation. The contractor, if there is a dispute about the lien that the government has imposed upon them or the arrearage that exists, that contractor has the ability to dispute that. And we have many, many, many instances where the taxpayer, be it a contractor or an employee, actually prevails, and that either the lien is not properly executed or that the amount in dispute is far less than what the taxpayer or the contractor owes. So that fight goes on. But what I want to point to is that under your amendment, the definition of seriously delinquent tax obligation is the issuance of a lien. Now, that lien is issued unilaterally. That is just the IRS coming in and saying, you owe us money. What your amendment would do for taxpayers is, for federal employees, would be when the when the IRS says to the employee, you owe us money, the trapdoor springs. Your amendment directs the federal agency to fire that employee just because the IRS has said, you owe us money. Now, you can say, well, they have a chance to fight that. The employee has a chance to fight that, but they don't have a job. And I don't know if you've talked to the IRS commissioner, and they've got this system in place right now.
Well,
and he tells me, please let me finish.
Yeah.
He tells me this is how bizarre it is on the IRS side. They have this system that you want to adopt for all federal employees. If an employee has money coming back, and many, many IRS employees claim single zero so they get money back at the end so they don't get into a problem, and you're right, they have a very low delinquency rate. If an employee at the IRS today claims single zero for the whole year, and their wife does the same, or their spouse does the same, and they don't file on time, they have a refund coming back. But if they don't file on time, the IRS commissioner has to fire them. That's the system that you want to apply to every single federal employee right now.
Will the gentleman yield on that point?
Briefly.
Please, I would encourage all members to look at the top of page 2, because these are the exclusions, and there are 2 of them. If a debt is being paid in a timely manner, pursue it to an agreement.
No, you're missing the point. I reclaim my time. Here's the deal. In many, many cases, the lien is the first actual knowledge on the part of the taxpayer. That's the beginning of the process. So there's no work, all the workouts that you talked about, the hundreds of thousands of people that are really working out their tax obligations, that happens after the lien. In your amendment, when the lien comes in, that person's fired. So the opportunity to get to pay arrearage is gone, the job is gone, the ability of the taxpayer to dispute whether the lien is proper or whether the amount is proper is gone, because that employee has had summary execution. They are gone. And that's what the IRS commissioner has had to deal with. And that's the situation that your amendment would invite. And here's what I'm saying. I think you have the best of intentions, Mr. Chaffetz, and you're an honorable man. But this is what happens when we try to do something without a hearing. I would like to bring all those federal agencies up here and make them testify, so you and I and the members of this committee and the members of Congress could get to the bottom of this and to say, okay, if an employee has reasonable notice and has just flat out refused to pay their taxes, well, you know, give them the axe.
Will the gentleman yield?
I will yield again.
The first time that an employee or a person, any person, hears about their tax situation is not when a lien shows up on their desk. There is a process that goes through to the point where the IRS gets to a point where they just don't believe that they're going to actually get this money back. So to
reclaim my time. I just want to let me give you a perfect example. Back a few years ago, right after Katrina, the area in Mississippi, Mississippi, Texas, and Louisiana had a vast number of people that the IRS could not contact because they had relocated. If the IRS can't contact people within a certain reasonable amount of time, then after, I think it's 2 or 3 efforts, they automatically put the lien in. That's just after no contact. That's not on the merits. That's just, we can't find you, we're going to lien you, or we can't get notice to you, we're going to lien your property. And that gets people's attention when you lien their assets, and that's when the process starts. Well, so that's the fundamental mechanical problem I have with your amendment, is that the lien is the first thing that many of these individuals are going to be hit with, and that's what makes their job go away. And also, in closing, and I think I've used my time, but okay. In closing, I would just say this, that the incidence of delinquency among federal employees is far, far, far lower than in the general population, as it should be.
Mr. Chairman.
Mr. Chairman.
Let me just say that, I think before we move any further, and I think that both of you have good points. I think Mr. Schaefer has good points, and I think Mr. Lynch has good points. And I have an amendment, I think, that might solve the problem. And I know I see a lot of hands going up, but, I also want to announce the fact that we do have a hearing immediately after this. So now I'll recognize you. But yes.
Thank you, Mr. Chairman. I'd like to yield my time to Mr. Chaffetz.
Thank you. When a lien is offered, and that's the very first time an employee hears about it, I think is a rare, very rare experience. You have to make some sort of, I think, a proper assumption that the IRS is doing the job the way it's supposed to. And if there are hearings and things that we should have, I will fully support on how they execute their duties, their roles, and their responsibilities. But again, would point back to page 2, where there are exclusions. If the debt's being paid in a timely manner, there's a due process hearing, that would not allow us to go just dismiss all of these people suddenly without any sort of notice.
Would
the gentleman yield?
The gentleman from Missouri has the time, but let me just say, I think that let me offer the amendment, and then let's speak on that. I think that might solve the problem.
Fair enough. Fair
Okay.
enough. Thank
All
you,
right.
Mr. Chairman.
Let's move forward.
Amendment offered by Mr. Towns to the amendment offered by Mr. Chaffetz. In Section 7381A1 of Title V, United States Code, as proposed to be added by the amendment. 1.
Without objection, the amendment is considered as read. I recognize myself for 5 minutes to speak on the amendment to the Chafee Amendment. The Office of Government Ethics outlines the responsibility of federal employees to satisfy in good faith their obligation as citizens, especially those such as federal, state, or local taxes that are imposed by law. As government lawyers, auditors, and inspectors, federal workers have a unique role in our society. They have a special duty to uphold their tax obligation and to set an example for the rest of our citizens. Recognizing this, in 1993, the Internal Revenue Service created the Federal Employees Retiree Delinquency Initiative to track and report on tax compliance among federal employees. This initiative includes IRS efforts to collect unpaid debt through a robust wage garnishment program specifically designed for federal employees. Because of these efforts, the tax compliance rate in the federal community is much better than the general public. However, federal and military personnel and retirees owe approximately $3 billion to the United States Treasury. This is a startling high total. The amendment offered by Mr. Chafee recognizes the importance of this issue, and I think we should recognize it. And I believe it is intended to strengthen the IRS's current federal employees initiative. However, the way the amendment is drafted, it could actually undermine the federal government's efforts to collect from delinquent federal employee accounts. I have prepared this second-degree amendment in order to help the government collect unpaid revenue from federal workers. And of course, because of the fact that I think the Chafee Amendment would improve the amendment by ensuring that federal employees receive due process similar to that which is provided to contractors in this bill. For example, the bill allows contractors who are paying back their debts under a payment plan to be eligible for contracts. My amendment would ensure that an employee who is having their wages garnished will continue to be eligible for employment. As a policy matter, it does not make any sense to fire somebody who's actively repaying their debt. My amendment would also make sure that existing due process protections apply to any action taken against an employee because of their tax status. Just as contractors receive due process through the debarment process. As drafted, the Chafee Amendment raises constitutional concerns and potentially conflict with long-standing civil service rules and regulations. In addition, my amendment would require the Office of Personnel Management to issue rules allowing an employee a reasonable amount of time to demonstrate they are paying their debt to the government before being fired. Again, if an employee has a paycheck that can be garnished, the government is more likely to be able to collect any unpaid taxes. The amendment would also allow for a hardship exemption when such an exemption is in the best interest of the United States. The IRS tells us that most employees with balances due are not tax evaders or tax cheats. Most file correct tax returns but cannot pay the full amount due when they file. Others may have fully paid when they file but later owe additional taxes because of audit adjustments or unable to pay immediately. This inability to pay could be for many, many reasons, such as emergency health costs. As we look to recover this unpaid revenue, we should not summarily dismiss employees with legitimate hardship to consider. I should also note that OPM and IRS have both raised general concerns about the potential administrative costs of enforcing this amendment. These agencies have not yet provided specifics, but if it turns out that the cost of enforcing this provision outweighs the potential benefit, I would have to rethink my support for this effort. I thank the gentleman from Utah for all of his hard work in terms of getting us to this point and time. and of course, and for his concerns about this issue, and hope he will support these necessary changes to ensure this amendment is not harsher on federal employees than it is on contractors. It's fair to federal employees who owe taxes, as well as fair to all our citizens who are paying taxes. Do any other member wish to be heard on the town's second-degree amendment? I recognize the ranking member from California, Congressman Issa.
Thank you, Mr. Chairman, and I understand that Mr. Chaffetz is prepared to accept your amendment. I am also prepared to accept your amendment. I believe that when we work together on a bipartisan basis, and when we view the world incrementally, I think we do good service. I think the American people expect us to do a good job of reducing this $3 billion backlog that still seems to persist. Some of it, in fact, could be by failure of the Office of Personnel Management to find ways to actually execute on existing laws. So as the subcommittee chairman said, I believe we need to have a future hearing at the subcommittee that would help us look further into this problem and see what we can do to improve both the contractor and the employee compliance. Lastly, I believe that we should be candid in recognizing that the vast majority of people who have seriously delinquent and substantial tax liens that are also federal employees, these liens most of the time occur from other than their federal salary. It occurs from outside businesses and other activities that create this. It is incredibly common for a federal employee and or their spouse to have a small business or some other activity. And I think we need to recognize that through the hearing process, through discovery, we can in fact build a database of understanding of how much of this is in fact people unwilling to meet the obligations from things they did outside the federal service who continue to serve. Lastly, I believe that we should all recognize that we already hold our men and women in uniform to a much higher standard. Men and women in uniform, all departments, are subject to the Uniform Code of Military Justice, which allows punishment under that for failure to meet financial responsibilities. So we do see those who give the most for our country and sometimes are paid less, or often are paid less, held to a higher standard. So I believe that the gentleman from Massachusetts makes the valid point that do what we can do today, then revisit this after we've held one or more hearings. I support that. I'm sure the gentleman from Utah does. I support the amendment and yield back.
I thank the gentleman for his remarks. If no other members wish to speak
Mr.
on the
Chairman?
perfect...
Mr. Chairman?
Yes, okay. Recognize the gentleman from Maryland.
Thank you very much, Mr. Chairman. Mr. Chairman, I first of all I wasn't even going to speak on this, but Mr. Chairman, I thank you for your very thoughtful amendment. I understand fully the gentleman's amendment in trying to get to people who may have tax problems, but we got to be realistic, and I think your amendment takes this into consideration. We're in difficult times, folks. A lot of people are struggling, doing the best they can with what they got. And a lot of times they do file. And, I mean, they file on time, do what they're supposed to do, and maybe they don't have the money at that moment, but they try. And they try very, very hard to do the right thing. And then, and I'm so glad that Mr. Lynch said what he said, because then you put them out of a job, then how are they going to pay? So I just think, Mr. Chairman, I really appreciate what you said, and I appreciate your thoughtfulness, because the people in my district, they want to pay. They don't want not to pay their taxes, and there are people all over this country who are in the same position. But sometimes I think we forget that we've got a lot of folks who have lost an income. Maybe a husband and wife were working and now it's only the wife working. Or maybe they've run into some difficulties, some problems. Again, like I said, they filed a tax return, they want to do the right thing, and they just don't have it. And so, but then again, they make the arrangements with IRS, hopefully, and they get it done. And the other question, and I was so glad, this is another reason I was glad Mr. Lynch chimed in, is the first thing I asked my staffer is what does, serious delinquent mean? I don't know, and so I think a full hearing would be a good thing. And I want to make it clear, Mr. Chairman, as I know you do, we're not talking about defending people who just go around not paying taxes and not fulfilling their responsibility. But at the same time, I think we have to have some balance here. And you can actually put a person in a worse position by taking away their job, then they're not able to do anything. And that's not, I don't think, what our intention in this Congress is. And sometimes, I listen to my constituents at town hall meetings, and they ask me, is there a disconnect between the Congress and us? And I think sometimes there is. Thank you, Mr. Chairman.
Thank you, gentleman from Maryland, for his very thoughtful statement. Gentlewoman from Washington, D.C.
Thank you very much, Mr. Chairman. I appreciate the way in which you and Mr. Chaffetz and Mr. Towns are dealing with this issue. I'm going to vote for this amendment at the same time that I want to indicate serious unreadiness. Part of it is the lawyer in me. When you thrust me into tax law and essentially tell me to tack on an amendment that has consequences both in civil service law, in Fifth and 14th Amendment due process terms, and in tax law, I have serious uneasiness. You relaxed that, Mr. Chairman, for me when you indicated that there would be a hearing. I can tell you without fear of contradiction that after a hearing there will be changes in this amendment. I do not know enough. I don't even know enough about the so-called 100,000 and the 3 billion, whether or not those are really people who have a lien and somehow are beginning to get out of it, but the lien is not gone yet. I really don't know enough, and the area is so convoluted because it involves overlapping areas of law, not to mention the fact that when a federal employee, or for that matter a contractor, is involved, because they're doing business with the federal government, the Constitution clicks in, and all kinds of due process matters that would not come in when for a private employer are considered, and people all of a sudden get rights that they do not have in private employment. For example, what Mr. Lynch said, that was the first time I heard anything about anybody's experience at the IRS. I knew the IRS had this notion, and I consider it most appropriate for the IRS, and for that matter, for everybody else to have it. I do know this, even though I agree with my good friend, Mr. Cummings. Nothing will outrage people more in the United States, hearing nothing else but that somebody's drawing a check from the United States government and not paying its taxes. They don't want to hear anything else. So I do think a balance needs to be struck. I do not want to be on the side of, you got a hardship, you're getting a federal check, therefore we'll take care of your hardship. I don't want to be on that side. On the other hand, I think there are genuine issues that can be solved once we have some facts before us. I don't think we should hold up this bill to get those facts before us. I even think, I must tell you, that we're putting a burden on the OPM that is completely impossible. They will have to issue regulations, or else seriously delinquent becomes a completely arbitrary standard. That means, your supervisor knows you're a good employee, and you've been trying hard, and you got 3 kids, and I'm going to make sure that you don't lose your job. They're going to have to define that in regulations. All of that is appropriate, and it has to happen in the federal sector. I believe what this bill does is important enough to proceed. If, Mr. Chairman, you are saying that we will have an early hearing so that we can avoid unintended consequences from the bill today.
I appreciate the gentlewoman from Washington's comment.
Mr. Chairman.
Recognize the gentleman from Missouri.
Thank you, Mr. Chairman. If I read the amendment correctly, you have applied this amendment only to the executive branch. Is that correct? Executive agency?
That's correct.
So we don't have anything with the legislative or judicial branches?
No,
of government?
only because that's the jurisdiction of this committee, and that's the reason why it's restricted.
That's the jurisdiction of this committee?
This
only?
committee.
This is a bill, though, it has implications across the board. Do we not have the ability to make law across the board?
If the gentleman would yield.
Sure.
Sequential referrals to other committees is ordinarily what occurs when it affects a committee jurisdiction that is specifically with another branch. That's the only reason that you're seeing it this way.
We don't have...
If the gentleman continue
Okay.
yielding,
Yeah,
when we do a markup on the portion which we control, and other committees get referrals for the markups they
Okay.
control.
Gotcha. Very good. Thank you. Thank you, Mr. Chairman.
But I understand your thinking.
Mr. Chairman,
Yes, gentleman from Massachusetts.
if I may. Mr. Chairman, I appreciate your attempt here at improving the amendment. However, with the greatest due respect to the chairman, I must speak in opposition to the gentleman's amendment. And the reason being that the same flaw that existed in the gentleman from Utah's amendment still exists, which is that the unilateral lien from the IRS is dispositive of the employee's job, so that they would still be required, when the lien comes down, it still constitutes serious delinquency, and the person must be dismissed. That's the reading of, that hasn't changed at all. You've amended a lot here, but you haven't amended that piece, as I understand it. And I just want to add a few things. I agree totally with the ranking member's position that 80% of these individual claims, which is the great majority of the tax gap, so to speak, in collections, has to do with business expenses, non-business expenses. Did the person take the right number of exemptions? Did the person take the right credits and deductions? So it's a real fight between the IRS and the taxpayer about what is proper. It's some of the finer points of tax law. What we're doing is we're taking the IRS's word for it, and we're saying their lien is proper, their amount is proper, and we're going to cut loose this federal employee based on the IRS's argument. Now, I think that is totally wrong. I think that due process requires that these employees would have a chance of disputing the amount and the propriety of the lien. I think you're taking, look, this is against federal employees today, but it might be against private employees tomorrow. And we want to give people the right to stand up and fight for their position. This is good government here we're trying to promote. And to say, okay, you can dispute your tax lien, but your job is gone, you're going to do it from the unemployment line, I think is a terrible, terrible approach. We also have very enhanced garnishment procedures for the IRS, where the government grabs 15% of every check to pay off that lien, which is far in excess of what we do for private employees. And I just think we would not be at this point if we had a full hearing on this. The last point I want to make is regarding our military employees. Military employees are only exempt if they're in a war zone. That's the way it works right now with the IRS. If they're in a war zone, so those 250,000 troops in Afghanistan and in Iraq, they're in war zones, they would be exempt. The millions and millions and millions and millions of other military are not exempt, okay? And I want you to remember that up until 2005, we had a ton of military personnel who were getting paid so low wages that they were eligible for food stamps, okay? So these are not highly paid people. Just because they're not in a war zone, they should not be subject to this type of treatment. They should have the ability to dispute the tax liens against them. I just think it's look, I think we would not be here if we had a full hearing. And all I'm asking is that the gentleman of Utah would withdraw his amendment. I'm the chair of the subcommittee on federal employees. We would have a full full hearing on this. We will subpoena if we have to, folks to come in and testify as to the real practice. We will have the IRS commissioner come here, tell us what the practice is right now, what the existing law and how it operates. Bring in the heads of these other departments if we believe them to be harboring, tax cheats, and try to get at the people who I think the gentleman is trying to get at, which is people who are, just obstinately and unreasonably refusing to pay their federal taxes. We should go after them. But when people are fighting because they're saying, look, I think I owe $2,000 and not $8,000, well, their job is going away, because you can't dispute part of this once the lien attaches, except from the unemployment line.
Would the gentleman yield? Would the gentleman yield?
I will yield, yes. I'm sorry.
I guess, are you asking there and ourselves to pull the bill at this time?
I'm asking to pull the amendment with respect to federal employees. I have jurisdiction over the subcommittee on federal employees. I think this intimately affects the working conditions of federal employees, and we can have a full hearing on that. It's the amendment that not the overall bill.
Mr. Chairman, if I may make a point, because this was a noticed markup, because the gentleman's amendment was even delivered to the other side, on the other committees I've served on, it's noticed to have your amendments to perfect something ready. If the chair believes that somehow has not occurred and wants to pull the bill and reschedule, the minority would not object to it being done. What I think we feel is that if there's been a notice and there's been actually delivery of an amendment, we really could not in good faith pull the amendment and allow the bill to go forward, so we'd have to pick between the two.
Right. And we really don't want to pull the bill. And let me just say one thing that might be helpful to you, that the military is not included. So you can rest for sure that that's not a situation. And I understood your point, and I think it's well taken, and I realize that there were some concerns. But the point is that I think that we have a vote on the floor, and that I think there's 3 votes. So I would like to dispose of this, now.
Mr. Chairman, can I very briefly, if I
I'll yield to the gentleman for Utah.
I just want to say I do appreciate the majority, and specifically Mr. Towns, in working with me on this. This Towns amendment is not my first choice, but I will support it. I have no desire to withdraw my underlying amendment. I think it could be stronger, but I'm going to support it. And I think the American people expect that we kind of work back and forth like this. Like I said, it's not my first choice, but I will support it. And I do think that there are plenty of provisions, multiple provisions, for somebody who's trying to do the right thing, who wants to go through due process, who wants to say, look, I'm making payments, I'm doing what I'm supposed to be doing.
But the gentleman yields, but that all happens after the lien, and the person's job is gone at that point. So you're providing rights to unemployed workers after you take their jobs away.
Gentleman from Massachusetts, I have the time. Let me just say this.
Thank you, Mr. Chairman.
Let me say this, thank you. That I hear you. I hear you and I also hear you. Let me say this, that what I will do is that we will not move it to the floor until we have a hearing. And then what I will do, and I will assure you, that I will work with you to try and get a technical amendment that might address the problems. And I understand the problems, and they're there. And of course, but I think that we want to move it forward, and then after that, we can continue to work. This is not the end. Okay, so if I can get that agreement from both of you, then we can move it forward.
We're going to have a hearing?
Yeah, I indicated that.
All
yes.
right. That would be great by me.
Yeah,
Thank you.
and then at the same time, as indicated, we then can move it forward.
Wait, whoa. I'm sorry. We're going to pass the bill, then have a hearing afterwards? Or?
Yeah, we can have.
Oh, no. Yeah, I'm sorry. I withdraw my cooperation.
I support you, Mr. Chairman.
No.
Before,
Mr. Chairman.
Yes.
Look, this is a huge issue for federal employees. This is a huge issue for federal employees. They have not got one word in the hearing here. This has all been backdoor without a hearing with an amendment
that came. Let me try
this
again. I think you misunderstood me. I indicated the fact that we will have a hearing, yes. And of course, what we can do is that we can, before we go to the floor of the House, and then we can amend it. I will offer a technical amendment, and you can have input in it, and of course, Mr. Schaefer can have input in it, and that we can move it forward. I mean, that's my commitment to you.
With all due,
I don't want to hold the
Mr. Chairman,
contract.
I have enormous respect for you, but I cannot agree to that. Have the bill go forward, and then we'll talk about it afterwards.
Well, is Mr. Chairman saying that the bill will not go forward until a hearing has been held to allow civil
That's
service to be heard and until the gentleman is satisfied?
That's exactly what the gentleman from New York is saying.
No, gentlemen,
Mr.
well,
Chairman?
I have enormous respect and trust for the chairman, but I would have to vote for this, and I cannot vote for this, and I don't think that the federal employees are having their rights protected here. I understand what we're going after, but I think this is a great disservice to federal employees doing it this way, you know, having it go forward and talking about it afterwards and trying to catch up to the bill. We don't handle other bills this way. Why are we doing this one?
Mr. Chairman.
Mr. Chairman, if you yield.
Yeah, I yield to the gentleman from Virginia.
I thank the chairman. Mr. Chairman, I want to thank you for the wisdom of Solomon and your attempt to bridge a very difficult issue. And I very much respect you and thank you for that effort. However, I think Mr. Lynch makes a profound point. I represent probably as many federal employees as anybody in this body. They deserve better than, frankly, our rushing to judgment on something so important. And while I fully trust you and understand what you're proposing, nonetheless we're being asked to vote and make a judgment on something I want to know a lot more about, and I know my constituents would want to know a lot more about. Quite frankly, it's easy to bash federal employees, I suppose, in other parts of the country, but these are hard-working men and women who serve their country, and the idea that somehow the IRS gets it right, and therefore anybody who's been charged with a serious delinquency must be wrong, would come as news to a lot of people, and I know my friends on the other side of the aisle have highlighted that problem, that the IRS often gets it wrong. And I would appeal to my friend from Utah to consider, for now, withdrawing his amendment so we could have the hearings, and all of us will work with him to try to get this right. But to rush to judgment, even with the very generous offer of the chairman, I think does a disservice to the men and women of the federal workforce, and I could not support this at this time.
Will the gentleman yield?
I yield.
Thank you. Mr. Chairman, may I just ask a question here? I mean, given the fact that the other body, the Senate, is sitting on 290 bills from the House of Representatives and has yet to act on them, is there some reason we can't just postpone this matter and have a hearing and then reconvene and consider the bill in its entirety? It's not as if we act today or even pass it in the House tomorrow, the Senate is going to get to this next.
Just before I
Thank you.
respond, I want to hear from the ranking member as well.
Thank you, Mr. Chairman.
And then I'll respond.
Very briefly, in those days when I was in the majority, this was not an uncommon event. Now we're in the minority. We would be less comfortable with assurances from the chairman than we would have been in the majority. However, it is extremely common when a scheduled markup occurs and a group not prepared to have amendments, but having concerns which are raised says, well, I'd like to continue working on it, to say before it goes to a vote of the full House, will you either guarantee me satisfaction in the management amendment or work with the Rules Committee to ensure that my amendment at the full House is in order? And I think you're being abundantly fair by not only doing both of those, but going one step further and guaranteeing a hearing in this committee, which we're in control of, prior to that. So I think you're giving your own side and our side the kind of opportunity to learn further against some points that were brought up here, to offer to put it in a manager's amendment. Certainly your side controls the Rules Committee, so amendments could be placed in order. But I do believe that this is a scheduled, noticed hearing. The amendment was noticed in a timely fashion. And although the concerns I've heard by the majority do beg for some technical correction, I don't think anyone here on either side of the aisle should claim that somehow a seriously delinquent, a tax cheat, if you will, somebody unwilling to pay long overdue bills, should be held to a standard different than we're going to hold our contractors to. So I do believe the gentleman from Utah is absolutely correct that we need to make sure we tie the two together, but there are protections that have been asked about here today that we would join with the majority in ensuring we're added for employees, and I yield back.
Right. Let me just say
Chairman?
this, so we have a vote on the floor. But anyway, let me say this, that you have my total assurance that we will not move this bill to the floor until we have a hearing. Now, if Mr. Chafee would withdraw his amendment, that would be fine. And let me just say that, my record on federal employees is pretty good. So I want you to know that. So I take, that very seriously. And I recognize the points that have been made. I think they're very important. But I will say to you, this bill will not go to the floor until we have a hearing. Now, if Mr. Chafee withdraws his amendment, then fine. But if not, I still give you that assurance.
Mr. Chairman?
Mr. Chairman?
Who is that? Oh, I'm sorry, Ms. Spear. Yeah.
Thank you, Mr. Chairman.
Yeah.
I, too, would like to associate
And I think we have to come back after this. Yeah. Go
I'd
ahead.
like to associate myself with the comments by the members from Massachusetts. 2 points I'd like to make. In some respects, the amendment by the gentleman from Utah is not germane to the bill before us because we were focused on corporations. To the extent that we are going to now include individuals, federal employees, the process should suggest to us that we have a hearing on that to determine what in effect is already in place as tools for the IRS and the federal government to garnish wages and the like. Beyond that, I think that moving forward, as the gentleman from Massachusetts said, to a rush to a decision on the House floor when it's going to sit over on the Senate side for another 2 years is not necessarily prudent. So I would like to associate myself with holding the bill, having a hearing on the tools that are available presently to deal with federal employees who don't pay their taxes. A deadbeat is a deadbeat, and I don't think we should be somehow protecting them. But I want to make sure that we are acting prudently and appropriately. And I might also add that if you look at this bill in the way that Mr. Javits suggests, then we should be pulling contracts from federal contractors today who are in arrearages in their tax payments. We're only looking at it prospectively for federal contractors, and yet for federal employees, we're looking at it retroactively. So I would suggest that there's areas that we've got to create some balance.
Let me recognize the person that represents more federal employees than any other district in the United States of America, Congresswoman Eleanor Holmes Norton.
Actually, I think Mr. Connolly, because Fairfax County is bigger, probably represents more. Mr. Chairman, I think I think this is not an amendment. I think it is a bill. I think this is a major bill. And I think you would get enormous credit if it were processed as a major bill rather than as a contentious matter. I am amazed that the minority does not see what we're doing together as important enough to rise to the level of a bill. It was introduced as an amendment to another bill. My friends, this is not an amendment. This is major. It's the likes of which we've never done to every federal employee. Some of the facts are just coming out. Mr. Town just said, oh, by the way, the military is excluded. Well, we were told the military wasn't. Do you really want us to vote on it, or is there any urgency? Let me say this. Normally what the chairman is trying to do in the best sense is reserved for technical amendments. Indeed, the ranking member has used that word, that when we have a technical amendment, this is the way we do it. This is not an amendment at all, much less a technical amendment. Okay. This is not something we want to fix. This is something about which almost nobody in this committee knows anything except what we have learned in this hearing. I am asking the ranking member in the spirit of cooperation if he will work with the chairman on a major bill that would keep anybody who works for the federal government from being a scofflaw, so that we could
The gentlelady
together
would
bring
yield.
this to the floor of the House of Representatives.
I will work with the chairman, absolutely, to try to find changes, but as you can imagine, over in the Senate right now, they're talking about a technical amendment that only requires 51 votes to a bill that needed 60. So the truth is that we do have a requirement to look at trains that are leaving the station and try to make them as complete in as many boxcars as possible. But I do look forward to working with the chairman on any procedure he'd like to have to bring this to a resolution.
Thank you, gentleman, for his comments. Let me just say this. First, I want to ask the gentleman from Utah if he will withdraw his amendment. If not, I'm going to withdraw the bill.
You're going to what?
Withdraw the bill.
I do not intend to withdraw the amendment, so.
Well, I'm going to withdraw the bill. Okay? We have a vote on the floor.
I thank the chairman. Thank you, Mr. Chairman.
We'll come back 10 minutes after the last vote. 10 minutes after the last vote, we will resume.
Protect that piece.
I know you were.
Oh, okay. I want to make that clear. Yeah.